Good morning, everyone, and welcome to FirstService Residential's legislative update, focusing on the 2021 laws and how they will impact your community association. We've assembled a great panel today of experts in the field of community association law to discuss these changes that were enacted during the 2021 legislative session and the potential impact on community associations. We'll also touch on some of the things that maybe didn't get enacted, but based on experience, we know we're likely to see them pop up again next year and years beyond. My name is Tony Calici. I'm special counsel to FirstService Residential. I've been with FirstService Residential for going on 19 years now, and I'm pleased to be presenting today's webinar along with Travis Moore, who is our legislative partner. Travis is the principal of Moore Relations and a longstanding partner of ours and friend. Travis and I have been working together on legislative issues for basically 19 years now. And as many of you know, the legislative session began on March 2nd, the annual 60-day session. This was a crazy year with COVID. Things were a little bit different, and Travis will tell us a little bit about that later on. But it was a very different year in how the process worked. But that didn't seem to stop the legislature. There were a lot of things done that impacted community associations, not all of which have been acted on yet by the governor, but because of the fact that most of these changes, some have already gone into effect, but some of the others would go into effect July 1st. We felt it was important to present these today and give you an idea, a heads up of what's going on so that you're ready if and when they do go into effect. We're going to focus on the bills, as I mentioned, that passed. We'll also touch on some of the others, as I mentioned, that did not pass. And just a couple of administrative type announcements. We are recording the webinar today. In the coming days, it'll be posted to our website. We'll also be sharing our legislative alert, and that you'll see in the chat box in the coming minutes. And as always, a general disclaimer we have to give. This presentation is not meant to be specific legal advice. You should consult your attorney, your association's attorney, so that they can advise you as to how these laws will impact your specific situation. As I mentioned, we've assembled a great panel of experts today, and these are people that I'm proud to call friends and compatriots who I've had the pleasure of working with for many, many years. All of them are certified condo and planned unit development attorneys, which is the highest level of certification in the field. As I said, we're lucky to have them here with us today. First, I'll introduce Marnie Dale Reagan. Marnie is a principal in Gursky and Reagan. Marnie, welcome. Good morning.
Good morning. Thank you so much.
Thanks. Next, Lee Katzman. Lee has been a friend of the industry for many, many years. He's the founding partner of Katzman and Chandler. Lee, welcome. Lee, unmute. You're muted, Lee.
See, I'm trying to comply and I muted myself. Thank you, Tony. Thanks to Travis, and thanks to FirstService for having me today.
Thanks, Lee. And last but certainly not least is Laura Manning Hudson. Laura is a shareholder in the Siegfried Rivera firm, and again has been doing this for a lot of years. Laura, welcome.
Thank you, Tony. Thank you for having me.
Great. So what I'd like to do at this point, I'd like to introduce, I mentioned Travis Moore. Travis is FirstService retained lobbyist. He also lobbies on behalf of other community association groups, CAI being one of them. And Travis is an invaluable resource to us because of his knowledge of, how the crazy world of Tallahassee functions. So Travis, welcome, and I'll turn the program over to you at this point in time.
Thanks, Tony. Thanks for the kind words and also for the invitation to be here. And thank you, Lee and Laura and Marnie for joining us, and for FirstService for putting this together, and for all of you that are taking time out to watch. It's important, as Tony said. A lot happened this session, and we're going to kind of get right into it. I think we have a good agenda today, a good program that'll be very helpful as we navigate common interest ownership law and the changes that were made during the session. There's the bills that we'll highlight and focus on will be the COVID liability bill, which of the bills that we'll be talking today, that's the only one that's been signed by the governor went into effect March 29th. So it is the law. So we'll talk about that. That'll be Senate Bill 72, the COVID liability bill. We'll talk about vacation rentals. We'll talk about insurance, and then a very large community association package that's very comprehensive. We'll spend a good amount of time on that. It has a lot of things in it that the legislature put together and in one package, something that we've been working on for a couple of years, some of the skeleton of it. So we'll talk about that. If you have any questions throughout the webinar, and I would be shocked if you didn't, please submit them. We really would like to hear from you. So please submit them through the Q&A option that's down on the on your control panel. And then if we don't have an opportunity to address your particular question, we'll be sure to have somebody from the team. Obviously, we'll follow up with you. So now, as I said, we're gonna start with the COVID liability bill and move into this discussion with our panelists. So, Laura, why don't you take us through the legislation again that now is the law for Florida, and what it means to condominium, community association, board members, managers, residents, et cetera.
Oh, hi, good morning. Yeah, basically Senate Bill 72, which has now been enacted, was a great bill that was passed to protect businesses and associations from liability for COVID-related claims. Essentially, as you know, over the past year, I know a big part of our practice legally has been protecting our clients from risk of liability, where there's been no insurance, to defend the claim for COVID, and we've had to, close down amenities. So what this bill does is provide protection for associations who have basically followed the rules during the COVID pandemic, and makes it harder or create some hurdles for plaintiffs to bring claims against an association or a business for COVID liability. And basically what the bill provides is that a plaintiff has to plead with particularity that the association was grossly negligent, and they must provide an affidavit from a healthcare practitioner saying that they believe with a reasonable degree of certainty that the COVID virus or the damages that the plaintiff is claiming were contracted from the defendant. The defendant, though, is immune from liability as long as they can show that they complied with any one of the innumerable rules that were put out. So either a CDC guideline or a state guideline or a local government guideline. If the defendant can show that they have complied with one of those guidelines, then they are immune from liability. So that is a great thing. It's just more to the effect of, associations can open up, businesses can open up. We've had a lot of amenities closed for a good part of the last year. So, because our clients have been fearful of the risk of liability. So this will ease that burden for our association clients. Absolutely.
Great, thank you very much, Laura. And again, if there's some questions, and this is something that obviously we're all been dealing with and learning on the go, but I think it's very important to provide some structure for associations so they begin to know what they can and cannot do regarding liability and opening and their facilities.
Travis?
Yes, Tony.
If I may, in the early drafts of the legislation, community associations weren't included. So it took some work to broaden the scope of what was initially on the table.
Right. Correct? This started last summer where they were putting together this bill at the direction of the governor. He put together a task force. We were able to be involved with that task force. And it was just kind of for-profit businesses and obviously associations, while we're corporations and organized under 617, our corporate statutes, we're not for-profit corporations. And so we wanted to make sure they were included, not just the associations, but the management companies, the vendors, those that are working with them, and rules and procedures and how to handle things were coming fast and furious from the CDC all the way down to city councils. And we were, associations were trying to deal with all of that. And so this says, hey, look, if you were following those rules and doing and making those efforts, you have some protection. And you're absolutely right, Tony, though. Originally, this was just something that associations weren't contemplated. And we were able to get involved to make sure that they were also included in this. Let's talk about vacation rentals. Always a hot topic. Whenever we poll association members, it's like vacation rentals and emotional support animals are kind of 1 and 2. So the vacation rental bills, they made their appearance again this year, as they do every year. And so, Lee, why don't we talk about the vacation rental issue, maybe what we were able to do to kind of mitigate any damage that would have happened to associations. But why don't we talk about that issue? And I know that's something that you were helping us with and were involved in.
I think Marnie was covering that one. Is that Marnie or me? No, me. Vacation rentals.
I'm giving it to you.
Okay. Okay. I got which bill was that, please?
That was 219. It was filed as House Bill 219, Senate Bill 522. And while you're just taking a look, I can also say that this year, last year when these bills came about, we were able to get language inserted late in the process, but inserted nonetheless, that said essentially associations, regardless of who's going to be controlling vacation rentals from a state or from a local government perspective with this preemption, the rules, the regulations, whatever your documents say, association are going to hold true and allow you to manage vacation rentals as you see fit and have regulated in your community. So we put that language in for 7, 18, 19, and 20 condos, co-ops, and HOAs. And then we also thought it was important to make sure that it wasn't just a snapshot in time, that it was whatever your documents say now or as amended in the future, because we didn't want to say, oh, well, as of July 1, let's say 2020, this is what your document said regarding rental restrictions. So therefore, if you changed them in 2023, it no longer, the rules of the game in 2020 applied. So we said, we allowed it to breathe and said, it can be now or in the future, whatever an association decides, that they are not preempted. So this year, when those bills started off, they started off with that exact same language in them in both the House and the Senate. So then we were monitoring and tracking and making sure that we were dealing with policymakers to make sure that those provisions stayed, and they did. So that if this bill had passed, associations would be protected, as has happened the last few years due to the fight really between local governments, hotels and motels, the platforms, the Airbnbs, the VRBOs, those industry fights and policy decisions ongoing at the Capitol. The bill did not pass. So nothing passed regarding vacation rentals this session, but we were able to be instrumental that even if it had, associations would be protected. But that would have been passed as 219 and 522. And so, Lee, do you have anything to add to that? I know that you're going to be speaking on the next issue, which is
I apologize. Yes, I was only doing past legislation. Oh, I apologize. No,
I know that's just an issue you'd been involved in.
It's an issue that's interesting actually, because it has to do with taxation, I think, more than anything else. I mean, locally, we have some associations and some city governments in Broward County where they actually regulate any kinds of rentals that are going on within community associations. And they actually require that the community associations actually register, the people who rent their units register with the city, pay a fee to do that, and the city gets revenue from that. So I think it's really a matter of trying the governments competing with each other, the state government and the local governments trying to compete with each other as far as who's going to obtain the revenue from these rentals that are really business transactions, not really residential dwellings use. You know what I'm saying? So you'll see more of this in the future as far as who's going to control that and who's going to basically be in charge of collecting that money. And I think it's more of a money issue than it is a control issue going forward. But I know that didn't pass. And that's where my mistake was. I thought we were talking about pass legislation, not things that didn't pass. And I apologize. No worries.
Yeah, that's an easy one as far as it did not pass. But again, something that we have to be engaged in. It'll be back. As you said, the money those bed taxes alone for, let's just say, Broward County. I mean, we're talking in the hundreds of millions. So it's from a fiscal and economic standpoint, it's something, regardless of who's controlling the noise, it's who's controlling those purse strings.
Yeah, legislation usually drills down to money. Unfortunately, it's about
you have
public interest.
the Airbnbs of the world. I mean, I think they had 38 registered lobbyists or something like that. So it's something that will be back and will always be engaged and involved in. We've had a lot of our association leaders that we work with, presidents of associations, and others have been very helpful because as Tony said, we can be talking to policymakers, walking the halls, and this year was quite different because we weren't allowed to walk the halls because of COVID. They had the Capitol locked down on us, but they really listened to those association presidents and leaders and residents. And so when they were speaking on, look, we've moved into this community based on these restrictions with rentals. If you want to live in a community that allows vacation rentals, they're being developed. They're developed now. That's your choice. Go there. But allow the the most local control there is. Allow the association to govern how they're going to handle these. Again, we were instrumental in making sure that they could not override what the associations have as documents. So as associations are looking at their documents and needing to deal with rental restrictions, getting those in place is important. Now we're going to shift, but stay with Lee because on insurance, and I know Lee has been involved, and there was a big insurance package that did pass this year. And then also, and we'll talk about this a little bit more with Marnie, there was a piece of the big association package that dealt with subrogation. That was an insurance piece that'll be very important for associations that we'll talk about. But Senate Bill 76 passed. It was one of the last bills that passed in the session, went back and forth between the industry and those consumers and others. So Lee, why don't we talk about that? Because I know associations are they're looking at their budget and they're seeing that insurance bill continue to rise and the availability of coverage continuing to go down. So why don't you walk us through 76, a little bit of 630, and then we'll kick it to Marnie for a little bit of the insurance piece there, and then the rest of that package.
Okay. So the reason why I'm speaking about this is because I feel very, very passionate about this issue. Insurance and associations especially is very complicated and difficult. It's usually one of the association's largest budget items. You all know that. And every year, if there is a storm, everybody gets taxed additionally by the state of Florida, and your premiums also go up. But after things happen like COVID and like these types of things, it's an excellent time for the insurance companies, who are the wealthiest and richest companies in the world, to cry how poor they are now and how they have to make changes to legislation and they have to charge more premiums because they're losing money. If you take a look at any kind of document off the internet or off of information that's given by the state or the government, you'll see that the assets of insurance companies have only gone up in the last 20 years. They have not gone down. They haven't experienced horrible losses. Actually, after storms happen, their profits usually increase, not decrease. Yes, there has been a lot of activity around the world and these claims, but what's happened in Senate Bill 76 that's passed already is, to me, a tragedy for residents and citizens of the state of Florida, because this is a very anti-friendly consumer bill. What this basically does is it makes it much, much harder for people who are injured from storms or other types of disasters to obtain proper legal counsel for the representation on a contingency fee basis, where they don't want to lay out potentially tens of thousands or hundreds of thousands or potentially millions of dollars in fighting for property damage claims. And what's happened is that they've done a lot of things that's basically causing a chilling effect on the ability for individuals, associations, or anybody that really has a claim to bring that claim and make it through the court to get compensated. Anybody who's dealt with insurance before and making an insurance claim understands the difficulty of that. And what these bills do, and really you need to review the entire bill. I mean, there's several sections of Senate Bill 76, but basically they do a few different things, the insurance companies, lobbyists, that they've accomplished. So they prohibit property insurance practices by contractors. So it used to be that if there was a roofing company, they would maybe be able to go to their clients, they see roof damage, and then they'd basically be able to advise their clients of who they could talk to about, bringing a claim or things like that. So they've caused a chilling effect basically on not really letting anybody communicate or consult or act on behalf of somebody else to try to encourage or have an insurance claim filed. The insurance companies see this as fraud against them when people file claims lots of times. I see it as people taking advantage of a contractual relationship they made. Very simply, there's a property needs to be insured, paid for insurance, there was a storm, damage happened, now they have to pay. Okay. And you would think that when that happens, it's an easy process. Anybody who's been through it knows it's not an easy process and anything but that. So this bill that's passed really provides a little bit of oversight on the property insurance from the OIR, but what it mostly does is it has a huge chilling effect. It provides a reduction of the existing, there's a 5-year statute of limitations on claims. It was where you have 3 years to bring your initial claim. And then if you didn't bring it in 3 years, you'd have, by the 3rd year, you'd have to file a supplemental claim or a new claim or an amended claim, or else you'd lose it. So even though you have 5 years statute of limitations, you only have 3 years to bring the claim originally. Now they just reduced that from 3 years to 2 years, okay? And the supplemental claim has to be provided even sooner now. So they're shortening timeframes and shortening periods and making it more difficult for insurers to bring their case forward, okay? We just had a case in an association where we just settled in a high 7-figure matter, and we had not even filed a lawsuit after 3 years because we were still trying to comply with conditions precedent to bring the lawsuit with the insurance company because they kept on asking for more information and more information. So this will make the process even more difficult. The worst part of it has to do with this issue about attorney's fees. Most everybody in the state of Florida, from a lawyer's point of view, when there's a hurricane claim you bring that on a contingency fee basis. That means that the lawyer is going to not charge the association or the client unless he wins money, or she wins money. And now what they've done is they've caused a chilling effect of that because they've taken the attorney's fees out of the equation. And they're saying basically, if before the storm they make a settlement with your association, let's say they pay you $200,000 for your damages, and you think the damages are $1 million, and then you go through the whole process of hiring a lawyer and going to court and suing the insurer for that, and then at the end you only get, let's say, it says if you get less than 20% of the disputed amount, each party pays its own attorney's fees and costs. So basically, whatever you end up with is going to be a shifting of the attorney's fee obligation to make it even more burdensome to the citizen or the person who's going after the case to be paid for their insurance premium, their insurance damages. So overall, this provision, which is Senate Bill 76, it really has a terrible chilling effect upon the citizens' ability to prevail in court and have the contract they entered into honored and paid for in lots of different ways. So whatever status we had previously with property insurance claims and the ability for a citizen to pursue those claims, it has now become harder. It's become a lot harder now.
Thank you, Lee. And I'll just add a little bit to that good explanation. Is essentially policymakers at the beginning of session went to the industry and said, look, why are rates going up? And why are you leaving the market? In commercial residential, in that space, we used to have 12, 15 carriers. Your agent would go out, he could get quotes. The supply and demand, the amounts were down. We now have, we started session with 4, we now have 3. Another one left the market. You got Citizens going up about, I think it was 3 to 7,000 policies a month or a week. It's growing, it's back to growing. So they said, what's going on? Obviously, there's nothing we can do, anybody can do about fires in California, hurricanes in Florida, freezes in Texas that led to water claims. That can't do anything about that. The reinsurance market, that's a global market that all these carriers have to buy from. They're dealing with all of those issues. So the reinsurance prices couldn't really deal with a whole lot of that. So they looked at it and they said it's fraud or attorney's fees and bringing these cases. And that's, this argument about where Florida has a lot more litigation and not as many claims. So that is why, to Lee's point, they went to look at those things. Like on the statute of limitations, they looked at, in Louisiana, it's 6 months. In other states, like Lee said, 5 years. So then they came down in the middle. They looked and they said, well, these IRMA claims that were so they came in and like Lee said, it now would be 2 years with another year for your supplemental claim. But that initial claim, you know, you're not bringing a supplemental claim unless you've got an original claim. So you're essentially at 2 years in hopes to do that. Now they had a piece in there originally that we were concerned about. All of these other things affected commercial, residential, and just the private single family home in an HOA deal. The roofing piece didn't affect commercial, residential, and those roofs, but it did affect the single family. And the argument was, well, you know, the roof coverage isn't a warranty. You don't get a full replacement coverage on a roof that's 12 years old. You know, you get what the value is now, et cetera, a whole big argument. But we did have, and that only affected single family homes, but we did have some concerns about it going too far. So that piece was taken out in the end. But time will tell. I don't think, and even the carriers say, and the proponents of this bill, nothing about this is going to drive rates down. What the hope is that it will just stop the rate increases so that the rate increases that we're seeing won't continue to climb in an effort to try to bring the market back, bring carriers back that'll write in this space. So we'll see. I you know, with the next session starting in January, bills will be starting to get filed again any minute. They'll start having committee meetings in September. I think this will be back. I mean, insurance is something that we're going to have to deal with climate change, sea level rise, resiliency, all of the other things that are happening with us, living in the coast. So I think it'll be back. One thing that did pass that I think will be a big help that will drive rates down is the subrogation piece that passed in part of 630 that brings the balance back to what it used to be prior to 2010, where an association master policy can't go after a unit owner's HO6 unit owner policy, and now a unit owner policy can't go after the association. So we bring that balance back. That will help a lot on the liability side of an association's policy, and this is just for condos. Just this is only in the condo world. But that's part of 630. So now she's been waiting patiently. Marnie, can you talk to us a little bit about 630, which is there was a lot in there that I think is good. There is a couple mixed bag issues, but I think it on balance, it's a very positive bill for associations.
Absolutely. Good morning. As Travis said, 630 it's a housekeeping bill. It applies to everyone and it's all over the place. It addresses some new and some old. And for those of you who are here today that are parts of homeowners associations or co-ops, bear with me. Much of this addresses condominiums, but you did get included. So I will try to make sure that I outline the areas in which it is HOA or co-op, but the vast majority, again, deals with condos. Initially, just as Travis was saying, the first portion deals with subrogation. And while it may have an initial negative aspect increase on your premiums, I think over time you will see the decreases, because as practitioners, we've seen a lot of these insurance companies going after the associations when the unit owner was negligent. So it's going to be a nice way to hopefully stall that out, bring insurance back to where it should be. A lot of people saw 15-20% increases this year. So anything that we can do to get that under control, I think is a wonderful thing. Speaking to something that is new that the association, all of our founders helped us out with in Tallahassee, is dealing with pandemics. Something that came up last year that was very confusing for practitioners and owners alike was dealing with emergency powers. And I think a lot of attorneys dealt very broadly and kind of grabbed extra power that maybe we didn't have until the DVPR came in. And we addressed, the pandemic as we would with emergency powers. We held board meetings, we closed down the building, closed down the amenities, did what we thought we needed to do in order to protect our residents and the staff within the buildings, within the homeowners associations and clubhouses. So something that was modified is in 718, 719, and 720. So this is everybody. The emergency powers were addressed and they were broadened to include pandemics. What it did was it made very specific the ability for the boards to hold their board meetings by video, by telephone, to post notice when they could or advise after the fact, to engage in contracts and to take certain actions to protect the memberships. One interesting aspect to it, though, and this was something that came up that I'm sure that Lee and Laura can both agree has occurred, was what do we do with real estate? What do we do with closings, with showings, with open houses? And the real estate lobby got very involved, and they jumped in there and have an exception written in there that while the associations have these broad powers, we can't go in there and stop anyone from accessing the units or the amenities as it would relate to a sale, lease, or other transfer. So there is that limitation there, and I think it's a very clear kind of slap back to associations from the real estate market after what the memberships tried to do to protect the property. So it is what it is. And again, with all of these bills, it was approved, but it's not yet law. Travis can speak to whether or not he thinks this is going to get vetoed, but I think right now the belief is that it's not going to. So that's something to keep in mind, whether the pandemic continues, we shut down again, or if something else were to come along our way. Next up, just for the HOAs, is association rental restrictions. There's a provision in the condominium statute that states that if you make certain amendments to your governing documents, it only applies to owners that vote for it or purchase after the fact. This is an instance where the HOA statute is coming more into line with the condo statute. So the same type of restrictions will apply. However, because there's always a however, if your proposed amendment relates to 6-month leases or 3 times a year, it will apply to everyone. So for those of you in a homeowners association, if you've got the ability to pass some amendments quickly, you might want to get out there. This is something, again, that would be July 1st. There is language talking about who a subsequent owner is. If it's an estate, if it's an heir, it's not going to be a change in ownership. So that exception for the applicability will apply to those individuals. Another instance of coming into the new and beginning to really be a 21st century statute is Chapter 718 is going to be amended to provide for a transfer fee of $150. While this may not even cover the background fees that many associations face, it helps. There's also a provision that is going to allow for an increase every 5 years based upon CPI. So that's a good step. But again, spouses, parents, and dependent children are going to be accepted. It's going to be one fee for any type of a family unit. Flipping back over to 720, I told you guys I would keep you engaged. With respect to providing notice to your members with respect to meetings or amendments or other such information, typically you had to go to the property appraiser's website to confirm ownership. Again, this is something I think that's going to look a lot more like a condo. You are allowed to use your unit roster, and the onus is on the owners to provide good information. And I think that's something that's very helpful to associations. When you have to go and chase your owners for good information, it's difficult. Place the burden on them, and it really helps the associations with respect to notice, assessment collection, and so forth. One limitation that was addressed to both co-ops and condominiums is that you cannot require an owner to give a reason for a records request. We see, I have a saying in my practice that it only takes one, and every association has at least one. So I'm sure you guys have those owners that make multiple records requests, fill up your manager's time, the pain that it is. While you can, both in HOAs and condos, have reasonable rules, how those are defined is a moving target at all times. But one thing that's nice is that you can pass those reasonable rules, but remember, you can't require an owner to provide you with a reason why they want a records request. So I don't think many associations were implementing that, but it's something to be careful of moving forward. With respect to your records requests, you now can have them on an app. Many associations take the guise of looking at records requests and saying, sometimes it's better to invite the owner into the office and paper them to death, and other times it's better to give them exactly what they want and email it to them. So while you have that ability, if you have, for condominiums with over 150 units, there's more provisions that are going to be allowed to have an app and to have your records on that app. And for some associations, or if you have a great management company like FirstService Residential, thank you very much, a lot of them have the websites and apps in place already, and it might be something to easily facilitate those records requests. And again, once you can do something like that, you take the onus off your managers to have to deal on a day-to-day basis with those items, and they can actually go straight to the owners. The owners can access the records, and a lot of that can be mitigated to really spend the time on the things that you want to do, which is a wonderful tool. With respect to both HOAs and condos, again, as I was saying, you can have a mobile website or a mobile app, I'm sorry, and you can have owners consent to receive notice based just through that notification. I would be cautious with this. Unless you have a clear consent, the default and statutory requirement is still going to be posting, mailing, and for larger condominiums to be posting it on their website. So I'd be a touch cautious for now, but I think the electronic aspect of the association practice is really starting to catch up. So it's a nice way to get back into the 21st century. I spoke in the very beginning about some new, some old. The next item really addresses the old. It applies to condos, co-ops, and HOAs. It allows a board of directors to remove discriminatory language from the governing documents. You see this a lot in homeowners associations, where there be like that old 1930s, 1940s. Some are racial, some deal with livestock, some deal with farming. If you see something that, whether federally mandated or just obsolete to that extent, that is no longer supported by law, the board of directors can go ahead and just get rid of those provisions by a majority vote. It's a nice way to clean up the documents without having to go through full provisions. I would suggest, if you're going to do this, you should always go to your council and just make sure that, and get their blessing that this is something that the board can do, that it's not more substantive that would actually require your association membership to get involved in, or as may be required by your governing documents. Again, another old item is, some of you condominium owners may recall several years ago that the statute was amended to provide for term limits. And there became a whole lot of confusion as to how that provision was supposed to be applied. Was it retroactive? Was it prospective? There was different decisions by the DBPR, different interpretations. Finally, the statute will be amended to say that as of July 1st, 2018, that provision is to be prospective, and that 8-year term limitation begins July 1st, 2018. So if you're a 7-8-year board member right now, you're perfectly safe and you can stay in place. And then good luck trying to find someone to take your position from you going forward. One other area that the condominium statute was clarified and addressed to read more like the DBPR rules, which I think is very helpful, is that it clarified that your notices before a second notice of an annual meeting had to be mailed 14 days in advance, and that window is 14 to 34 days prior. So if you wonder why the 34 is there, if you recall, you have in a condominium 40 days prior to your election to submit your intent, and 35 days prior in order to submit your bio sheet. So that 34 days starts the very next day. If you have lickety-split council or management, you can meet that deadline. Obviously, the politics of that have nothing to do with this, of whether your board wants those mailings to go sooner or later. That's still going to be within your discretion, but it's just a clarification of what that window is going to be. One area that I think has been very helpful for condos, co-ops, and HOAs is your dispute resolution options. What they've done is the legislature has added some options for you. You have mediation as an option in areas where you traditionally just had arbitration. This is a nice way to open up the avenues, hopefully streamline the process. In a condominium, you can now utilize a pre-suit mediation similar to an HOA. And it's a nice tool to have, but you have to remember that with respect to recalls, you're still going to be limited to just the DBPR. They've maintained that sole jurisdiction, and it's something to be mindful of. Otherwise, I think that the tools to really try and broaden that ability to get the relief more quickly is something that you should speak with counsel about, and try and find the fastest resolution to get where your association is needing to go. An area for condominiums, and I know this is a lot, but this is a longer bell. With respect to condominiums, there was some back and forth in the statute a few years ago relating to conflicts of board members and how the associations could contract for their goods and services. There was language that you could contract with a board member's company or if they had a financial interest, and then there was language that you couldn't, and then there was language about disclosure. Well, it's now been clarified that you can, in fact, contract with a company that a board member has a fiduciary interest or a fiduciary gain from, so long as you disclose it. So just make sure as your associations, whether you're a board member or a manager, as you go forward, if that's going to be the case, and a lot of times I think a lot of associations shy away from that just for the appearance and the optics. But if you are going to contract with that company, make sure that you have a properly noticed board meeting and you disclose that relationship. It will protect everyone. Going back to the association law getting more proactive, we have language for condominiums relating to electric charging stations, as well as natural gas fueling stations. And I'm sure you can guess where that lobby came from. What we can do now is we can install those on the common elements in common element parking spaces, and we can determine how we're going to install it, how we're going to insure it, how we're going to use it, and how we're going to pay for it, and how owners that utilize those charging stations, how they're going to pay for it. So it really starts to become a more viable option for associations. The only problem is they haven't figured out how to create more parking spaces. For a lot of condominiums, that's the bigger issue. But it's an option now, and as we see more and more of these electric charging cars and natural gas cars, this will be something that the associations are going to need to deal with. Again, don't know how to create more parking, but we'll get there when we can. Maybe flying cars, I'm not sure. There was a clarification in the condominium statute relating to intents to lien, and they are now clarified to be deemed delivered on mailing. It's kind of the postal rule. So I would still make sure, and this is more of an attorney rule, is just make sure you're abiding by all of those restrictions. The last thing you want to do in a collection process is get to the end and realize you missed a mailing deadline. Be a touch embarrassing, and it also can become very costly. Fines. Speaking of money and how to get some money to continue to fund everything that we're doing, there's a lot of confusion in the statute in recent amendments relating to fining. Fining and suspension of use rights are wonderful tools, but there became confusion when the statute was amended to state that a fine was due 5 days after it was levied. That was contradictory to language stating that before that the associations had 7 days afterwards to provide notice. So those deadlines got a little skewed. What has now been clarified in both the condominium and the homeowners association law will be that fine is due 5 days after the association has provided notice that it was passed. So it gives a clear deadline. Again, when you look to fines and suspensions, you're looking to change behavior, not necessarily create an income source. So associations can look at that and be benevolent or not if need be, and collect that money, which frankly would probably just offset the cost of going through that process. With respect to official records and condominiums only, the statute was changed a few years ago relating to official records and seemed to suggest that all records from the beginning of time were to be kept in the association's office or now on websites. And as of this law, if it passes, mobile apps. One thing that was clarified was bids. With respect to bids, you needed to summarize or keep the bids for a certain period of time, but it seemed a little ridiculous to be keeping 12 bids from 18 different projects forever. So now the association law has been clarified for condominiums and said that the bids must be kept for 1 year after their receipt. After that, you can get rid of them. With today's world of scanning, you certainly can keep it in that way, but it's no longer necessary to have it front and center. For staying on the money tract, but going over to homeowners associations, reserves are a very common provision, function, and requirement in condominium law. However, in homeowners associations, reserve accounts only needed to be in place if they were there prior to turnover, if the developer created them, or if the association created them post-turnover. Something that we started to see, and this was probably more in Central Florida and North Florida, is properties were being developed where the developer would place $1 in the reserve account. This created a tremendous financial burden for associations because the developer didn't fund the reserves, yet the membership was required to fund it thereafter. This provision of the statute that is to be amended makes it very clear that if there are to be reserves, they have to be provided for in the declaration of the homeowners association documents, or created after the fact by the association membership. There, if you're going to have these association reserves, it's a membership decision. And I think really that's the way it should be. Reserves are always a good idea. It's pay now or pay later. So you can choose to fund over time or be specially assessed if need be. But in a homeowners association, there's a lot, I would say fewer issues that could be addressed, but they are bigger dollars. When you're talking about private roads and the such, and clubhouses can get very expensive. With respect to development itself, kind of picking on the developers, what we've seen changed in the condominium statute is that prior to this language, only a certain portion of sales and reservation deposits could be utilized for the developer with respect to the project. Now, all the sale and reservation deposits can be utilized for the actual construction after the 10%, but you can't use it for any marketing, attorney's fees, loans, insurance, or accounting. So it's another way for these developers to finish out these projects, hopefully turn them over in a financially responsible fashion and move forward. Now I'm going to pick on just the co-ops because this is something that was already permitted in the condos and the HOAs, but there was clarification to the law that you can now use phone and video conferencing for board meetings and committee member meetings. It will count towards a quorum and you can actually vote that way. This is something else I think that is helped by the pandemic aspect of the statute that I referred to earlier, is it really gave clarifications to all the community associations on how they could operate and function in their business when you have situations like these. Now, mind you, with that provision to the co-op, it's all the time, not just in emergency situations. Last two items, but certainly not least, are dealing only with the HOAs. Your election records, just like a condominium now, are going to have to be kept for 1 year. So that's going to include the limited proxies if you need them for quorum. It's going to include all of your ballots, tally sheets, and the like. All of that is going to be 1 year again. Finally, picking on my one owner, because there is one in every association. If you have that one owner that wants your gate records and wants to go harass people on who's coming in and the parties, that is not going to be an official record that your homeowners can request on a daily basis, monthly basis, weekly basis. So while it doesn't necessarily provide privacy for everyone, it gives just a touch more and maybe hopefully a little bit of assistance to your managers. So like I said, it was a very, very large bill and I skimmed over it to give you guys the glossing. Councils are obviously required to deal with this in much more depth. And so any questions you have regarding the changes, certainly speak with your counsel. And obviously the three of us are happy to assist as well. So Travis, all back to you.
Thank you so much, Marnie. And you can now get a much deserved drink of water to refresh your throat. So thank you. And as you mentioned early, it is expected to be signed by the governor. Again, these bills have not gone to the governor. Once they do, he'll have 15 days to act on them. And then this one would go into effect July 1. So it'll go to him soon. And things like a lot of it, like I had said in my opening remarks, were things that we've been working on for a while: the term limits piece, the mobile app piece, a lot of the conflicts of interest clarification, arbitration for condos. But the piece that this year, one of the pieces, that was new was the emergency powers that came. We started on it immediately this summer. Tony and a lot of us were working with the governor's office, with DBPR secretary, put out kind of like an emergency declaration, emergency order in the summer, because associations had emergency powers if the governor had declared an emergency, but only for natural disasters, because those are the things that we had dealt with in the past, hurricanes, et cetera. So we never had contemplated a public health disaster or crisis. So we essentially codified what those rules that we've all been operating in under since June, the spring of last year. We kind of just codified them in that bill. So there were other bills that passed that we can talk about very briefly. A lot of these will be in the legislative alert and summary that FirstService has sent out that you'll be getting from different law firms and others. One of them, House Bill 463, dealing with community association pools, only affects HOAs. It does the same thing that already is the law for condos and co-ops. Now for HOAs with 32 or fewer units, they are now exempt from the Department of Health, supervision, from that additional oversight from the Department of Health for those small communities. So if it works for, for condos and co-ops, it should also, we thought, hey, this should apply for private community HOA pools as well in those small communities. There's a bill 649 dealing with property tax assessment petitions, and associations, condos could challenge their assessment as an association before a county value adjustment board if they were arguing that the property appraiser had assessed them wrong on property tax. But if it had gone to circuit or county court, all the units in that building had to go separately as a separate court case. Now they can go to court as an association together and maintain that association almost like a class action for the association. One bill, let me just, there's going to be two, and I'm going to mention something. I'm going to kick back over real quick to Lee. One bill was on the last bill really that passed this session was dealing with home-based businesses. And immediately we had some concerns. It was preempting local governments from being able to regulate home-based businesses. The thought was that they always used was that the policymakers used was, well, we don't want to discourage the next, Apple that was founded in a garage from being founded in a garage in Florida. My concern was, well, I don't want a CrossFit operation to be operating out of a garage in an HOA. So there needs to be a balance. They worked through this bill. It was the last bill that passed. But early on, we had some concerns that it might be a backdoor-ish kind of thing for vacation rentals, but also that associations would lose their ability, like local governments, to control what's going on as far as businesses in communities, probably more in an HOA. So we put in the exact same language that we put into the bill dealing with vacation rentals, saying this does not apply to associations, can still maintain the rules as they see fit for their associations. So we put that in just in case it had passed. We made sure throughout all of these changes, and in every committee it changed, and on the floor it changed, that piece, that association protection language stayed in, and it did. So it passed. That was House Bill 403. Again, has not been signed by the governor, but associations are protected. Another one was that started off horrendous, ended up being bad, I think, is Senate Bill 56, dealing with community association assessment notices and some collection issues. We're working now, there's some people that, panelists on this call, and we are working with the governor's office. We have a meeting tomorrow even to talk about our concerns. Lee, do you mind, I know I'm kind of surprising you maybe with this, but do you mind just mentioning something on that real quickly while we have some time? Again, it started off, you're muted, Lee, you're muted. But I just also want to say it started off way worse, that every association would have every month had to send a statement of account by regular mail to everybody in their association, which would be thousands and thousands and thousands of dollars. But Lee?
Yes,
thought?
no worries. Yes, so Senate Bill 56. To me, it's a very complicated bill. I think it's poorly drafted. I think it leaves a lot of loopholes, and it's going to hurt associations, and it's especially going to hurt the people who are delinquent. The reason for that is that this puts certain requirements in place that were previously not in effect for condominiums, co-ops, and HOAs. If you remember or recall, HOAs were 45-day statutory limitations on responding to demand letters and lien letters. Condos are always 30. So they've made that change and made it from 30 to 45, which is fine, which is not a big deal. It does, again, take longer than to collect money that's owed by owners. I think the biggest problem with this Senate Bill 56 is that it's trying to legislate the exception and not the rule. And, it's a very basic principle. The majority of association members aren't delinquent. Not even 25%, not even 10%. Typically, you're looking at a 3 to 5% delinquency, that people either missed the bill, didn't pay their bills, can't pay their bills, whatever reasons, but it's a very small fraction. So when we over legislate these issues and try to control too much about how delinquent owner accounts are processed, it becomes complicated. And here's the complication with this one. This provides that before the association go forward and charge attorney's fees to a delinquent owner, a notice must be sent by the management company or the association, which notifies the owner of the delinquency. But they've included in this statutory legislation a form that has to be filled out by either the board or management, which includes calculations, okay? And that's where it gets complicated. So if an owner is delinquent, every management company maintains a ledger of what the owner's credits and debits are, and they could easily provide a ledger. Federal law usually requires, and state law requires, something called verification of debt. Verification of debt is the provision of a ledger, okay? But what the legislature in Senate Bill 56 is asking management companies to do now, when boards to do now across the board, is that every time an owner becomes delinquent, the first letter that really has to go out now is this letter that's required by this Senate Bill 56, which requires the management company to provide a breakdown, almost like a payoff letter, inclusive of interest to be calculated against the owner. Now, remember, if the owner's delinquent 15 days, how much interest has accumulated at this point in time? Even though it's 18% per annum, typically on newer associations, you're still talking about pennies and fractional amounts. It also requires the association or the management company to fall into a trap of unlicensed practice of law, because they then have to determine when the point of delinquency occurred. Okay, that gets complicated as well. But the biggest complication is this: while the statutory, what legislation basically says you can't collect attorney's fees, it doesn't say anything about collecting collection costs. And we all know that collection costs that are, management companies, when they do preliminary delinquent account collection services, incur expense and costs. FirstService's accountants in that company, when people are delinquent, they have to send letters, they have to bring money in, and all that takes time and effort. There are costs of collection with delinquent people, okay? So the problem is now you can't levy attorney's fees, we understand, but this expense for management companies is going to be huge. Also for boards is going to be huge. So let's say they incur this expense, right? Who's going to pay for it? Are some management companies going to charge the expense back to the delinquent owner? That's going to make the delinquent owner's account even more burdensome to them, which is certainly not what this bill intends to do. This bill wants to make it better for delinquent owners, not worse. But this bill, in essence, will make it worse for them because it's going to be expensive for them to charge for those letters to be prepared. And they have the right under the statute now in different sections to charge for collection costs. So it's actually creating the opposite. Also, it should be just a verification of debt. This bill, while it has a good intention, I think is not drafted right now the way it needs to be, and will cause great expense to not only delinquent owners, but also the association as a whole and paying owners. I really think this bill is a little bit not ripe for being put into law. I think that I believe it very strongly. It should be vetoed and it should be retooled for next session, which can be early on, either end of this year or early next year. And we can give the legislature something that they want and to achieve, which is a kinder effort towards delinquent owners without causing huge expense to associations and burdens to management companies who manage those associations and boards as well. In addition, one last thing is that if this is implemented into law and it does go through, I will tell you that it will be unbelievably expensive, unbelievably burdensome for management companies. And when the lawyers that have to pursue those accounts, that when the owner does not pay management after demand, the lawyers will be put in a terrible situation because they will then have to deal with this letter that went out by management company. If anything is not the same, if the interest calculation on management is off by a penny and the law firm wants to pursue interest and it's off by a penny, there will be lawsuits, federal and state, against law firms pursuing these debts on the federal Fair Debt Collection Practices Act, on the federal law, and also on the state law. So it's going to create a whole nightmare with absolutely no benefit to delinquent owners as the Senate bill intended. So we think it needs to be tooling. We think it needs to be vetoed. And, we're all going to work very hard until the governor either he signs that document vetoing it, or it just turns into law. But it's a very hazardous bill to associations.
Thank you, Lee. And
sure.
We could all meet in phase 2 at the pub. All 100 and some of us that are on here, and could talk about how these things became passed in the first place and became bills. And just the pieces that Marnie was talking about in the big package, each one of those has an interest and has, folks that were working on it. So that's how that all gets cobbled together. So that's a webinar, a whole nother bunch of fun. Tony.
Travis, yeah, before we jump off that,
Yeah.
So to amplify Lee's point, what we found is that a vast majority of collection matters can be resolved at an early stage with a simple reminder letter. And now with this legislation, if it's enacted, if it's approved, we're going to find, as Lee mentioned, additional cost in the process because associations aren't going to willing to create further delay by sending a friendly reminder that's not in the statutory form and then having to send the statutory notice before they can move on to the next stage. So it is going to become more expensive for delinquent owners.
Exactly. Now that friendly reminder all of a sudden will not be just the friendly free reminder. It'll be more ominous than that.
Exactly. And to your point as well, and I think it's important not to just gloss over it, this legislation didn't result from a groundswell of complaints from consumers who were being victimized by their associations. This legislation arose because of one individual in a very, very powerful legislative position who had a problem with his own homeowners association, and as a result felt this legislation was necessary. And unfortunately, it's oftentimes the way our legislative process works,
Yep.
that, we're legislating for the masses where a problem doesn't really exist just because of one individual's misunderstanding and miscommunication with his own association. So,
Right. Yeah. One person's experience shouldn't be, the rule for 50,000 associations and the 10 million Floridians that live in them. And exactly. Good point, Tony. And so while you still have the floor, I think we've covered in the time allotted that we have a kind of an overview and a highlight of a lot of the things that passed. So I'm going to kick it back to you, see if we have any questions and any further discussion.
We do have some questions coming in, and for those of you that maybe have a question and haven't submitted it, you can go ahead and submit it. For all the ones that we can't get to today, we will provide you an answer following the seminar, from our panel. So I would encourage you to submit those questions. And again, a copy of the legislative alert you can see in your chat box down below on your screen. You can click that and find a link to the legislative alert that you can download. The other thing, Travis, before we jump into the questions is on the DBPR bill that did not pass. I think it's important for us to maybe look at that for a second. That's where the checklist requirement was. Unmute there. Travis, unmute.
Sorry about that. Yes, Tony, there were a couple of DBPR bills, one of which had the checklist issue in it, where it was going to be very burdensome for an association to keep this checklist of all of these records and just an administrative nightmare. We were able to get that, and then they were trying to put it in other things. We were able to keep that bill from passing, keep it out of other things. And then the DBPR bill that did pass dealt with just a couple of small little changes, but nothing nothing, to deal with the budget and that kind of stuff, but nothing is onerous. And only for obviously, because it's DBPR, only for condos and co-ops, since they don't have jurisdiction over HOAs. But the big checklist issue did not pass.
Okay, good. I know, Travis, you've been answering some of the questions as they've come in. We've got a few others that we can try to get to. One of the questions came in was, do we still need to keep 6 feet apart for pool and gym, or can we open fully without restriction? Laura, you want to take that?
Yeah, I can take that. The CDC guidelines right now, if you go to cdc.gov right now, they've enacted guidelines for if you're vaccinated versus non-vaccinated, if you're outdoors versus indoors, do you wear a mask versus not wear a mask? So for the pool, basically what the CDC guidelines have said is that for pools, that's outdoors, you can be outdoors, not wear a face mask, and you don't need to be 6 feet apart. If you're, but if you're inside in a gym, like it says, face masks are still required. If you're indoors, even if you're vaccinated, and being the association practitioner, 6 feet apart is still a good rule of thumb indoors in a gym where sweat is flying, and a lot of mouth breathing is going on.
Great. Travis, coastal communities, one question regarding anything to help us deal with derelict vessels. There was that.
Good question. Yes, there was Senate Bill 1086 passed. For those of you that are keeping track and score at home. And by the way, you can go to www.flsenate.gov and put in the bill numbers and check this. As of now, they're still set for the 2021 session. Starting next week, they have a special session on gaming. It'll be defaulted to 2021A. So you'll have to change the little drop down. But if you look at 1086, it was a big bill dealing with boating that Fish and Wildlife Conservation Commission was working on. It's expected to get signed since that's an executive branch agency. But we were able to put in a piece that we were working with some communities like in the Tampa Bay area with the city of St. Petersburg that make it a lot easier and efficient for associations to have derelict vessels removed and the right person, be charged for those, et cetera. And they can work. So it does help deal with the derelict vessel issue, makes it much easier. And that's language is in 1086. So if you're talking to your counsel or your manager or anybody, that's where to point them to that exact language.
Okay, thanks, Travis. I want to be sensitive to everybody's time. We have other questions and answers that have come in, but we will try to get them to them after the webinar. I'd like to give our panelists an opportunity. Anybody want to offer some final words on what happened this year, what we can expect to see in the future? Lee?
Sure. I'll give you an oversight. It's been an active session, and it's really funny that the activity has been so great this year after COVID and everything else. What's funny that Travis talks about and what Tony talks about is a lot of the history of what it's like going to Tallahassee and understanding the way these things start out as a problem or an idea by somebody and how it actually gets in front of legislators and how it becomes a bill and how it goes in front of the governor. As Tony and Travis were saying before, these things come about in strange ways. Somebody has a problem and they go to the legislator, and then the legislator takes that up and then it goes up. But Florida is also a part-time legislature. It's not a full-time legislature, and there's lots of laws. We have a lot of people live in this state, and it's really such a short snippet of time that the legislators actually have to vote on these bills that are proposed to them. They don't really know much about them. There's so many that pass through them. So each bill has a champion as sponsors and tries to really do what they can with people in the industry. The biggest problem that you have with legislation, lots of times, like the perfect example is this Senate Bill 56. When a bill starts out, it starts out as somebody's idea. Hopefully good lawyers that are in the association industry and understand legislation, understand the real consequence of what happens when you put things in statute and then the actual application of that statutory reference to real life, okay? And what happens is lots of times legislation, it gets sort of like mucked up. It starts out nice, and then everybody tries to jump on and add things and take things away from it. And if they see it's going to pass, they want to throw things on it because it might get through the governor's desk. And it becomes sometimes things that started out with a good idea but are bad. I mean, in the past, we've helped legislation go through, and we've actually had to create bills for associations and then had to kill our own bills because they got so tagged on with things that it became a nuisance. So, the most important thing, I think, with any legislation is that the voices of the people who work in that industry are heard by legislators, are understood by legislators. And the problem that I see that happened this year is that a lot of these bills, while they work through potentially lots of people, there were a lot of people's hands in them that don't have day-to-day operation experience with how associations operate, what the real level of delinquency is there a problem with potentially with collecting debt or not, and do management do their job? Does management do their job or not? So a lot of these things are complicated, and I will tell you that the biggest thing that you have to remember is that the strongest voices in this state regarding legislation are the voices of the people that live in community associations. We are the largest lobby in the state if we want to be. We could be the most powerful voice in this state. There have been associations that have almost single-handedly elected senators and state representatives because of the power of their votes. And really calling together, as you know, what FirstService does and what Travis is doing as a lobbyist, and what, you know, Laura's firm and Marnie's firm and my firm do, is we all want to get together. We want to, you know, make the voices of the people that we work with and for louder, so our legislators can hear them clearly and can really legislate laws that are going to help our associations and help our communities' pockets, not hurt them. And I think this year, while there were good intentions, some of these things are really going to hurt consumers and community associations. So hopefully in the years to come, we'll have a more unified voice and scream as loud as we can. The vocal minority or majority.
Agreed, Lee. Yeah, it is. These voices do matter. And these members are home. You know, it's not like members of Congress where they're there all the time in session. I mean, they're here. So as they listen, and they need to be hearing the good stories and the good things that are happening in their associations, not just the problems, which then get filed into a bill and then we deal with it that way. So it is very important to be actively engaged. And that was a very moving speech, Lee. And if you've got your campaign account open.
I didn't mean it to be a speech, and I apologize, but I will tell you that I want to thank you, Travis, for being an advocate for associations for so many years now, and also Tony and FirstService for all their part in representing the interests of community associations and vendors and lawyers and everybody else.
Thank you, Lee. I appreciate that. As does FirstService, I know. Real quick, because we had one other question pop up where it says, can an association still limit use of amenities to residents? And before I kick that around to our legal panel, I just want to say, and this kind of dovetails into what Lee and Tony and others have said, you know, we don't operate in a vacuum. You know, we've had years where somebody wasn't able to park their police vehicle in their, you know, home driveway. That gets in the paper. The next thing you know, there's a bill filed, and it starts with, you know, no work. You can't say no work vehicles, and we have to deal with making it just, you know, police vehicles. And this, you know, there was recently an article in the Sun Sentinel, and I got a call from a state senator who read about it, and it's in, you know, in her district. I won't be any more specific than that, but she said, these people they're not able to use their pool, their tennis courts, nothing. And they're paying association fees and dues. And that's an amenity that they pay for. I can understand a balance, but this looks like it's out, you know, gone a little bit too far. So Marnie, I'm going to pick you to answer that question. But we just need to be mindful that when we're making these decisions, or as associations are making these decisions, they're able to make, that we're also being mindful of the fact that these are amenities that people, you know, that are part of their home.
Absolutely. I think, you know, at the end of the day, when you as a board member, you're a volunteer. You've gone professional in something else, and you have to rely upon the professionals that you've surrounded yourself with. You also have business judgment. So whatever you do that's reasonable is likely going to be upheld. And I think that in a certain situation, you know, you get a high rise with 400 units. If you want to regulate the amenity use, and whether it be the number of people, times, I'm starting to see time slots of people that have been vaccinated. Obviously, you can't ask if they've been vaccinated, but those that are willing to take that risk. I'm seeing, you know, morning open gyms, and then in the afternoons you can reserve slots. But I think at the end of the day, as long as what the associations are doing is reasonable, you're protected. And at the end of the day, you have health, safety, and welfare on your side. You're going to be able to pass rules and regulations that protect your membership. And I think you're going to be hard pressed if you're challenged saying that you're just trying to keep your membership safe. That being said, Florida is a very, very diverse state. We have areas of the state that I'm not going to say that weren't affected, but certainly weren't affected or don't have the density population that, you know, we in South Florida have. So everything has to be taken in the vacuum in which you've got it. But I think that, so the short answer to the lawyer's answer is yes, I think you still can restrict, but it has to be reasonable.
Thank you, Marnie. And
Um,
Laura, any final parting words for us today?
My only parting words was what I was thinking while Lee was talking, and I was looking at us all up on this Zoom call. Is our Zoom call is going to be here to stay? I noticed in some of the legislation that was passed, Travis, that in the part of the Emergency Act, is they said Zoom conference calls are going to be okay for emergency situations. But there was no similar provision made in the rest of the Condominium Act. And now everybody wants to know, are Zoom calls here to stay? So, I wonder if that's going to be something that we see in the future, because this has been a great tool that we've all gotten used to using. But are we going to be required when this emergency order is lifted at the end of June in our state? We're going to have to go back to in-person for all things condominium. And so, that's where my mind has been going watching this on the screen.
And that's an excellent observation. I think it will be an option that is here to stay. Just like, electronic voting, e-voting was, no, we don't want, and then people realizing, no, this will get us more people voting, maybe they're away in Ohio or Michigan or wherever, but this will allow them to continue to vote. And those policymakers were telling me, look, Travis, I want my association members to be able to sit at the pool, look at their phone and vote on something. So I think there was a question earlier about, will we be able to eventually as board members vote on things over email? Nothing passed this year on that, but I can see with things like Zoom and other things, that discussion's happening. And it's important to stay, again, engaged on these issues, because I think that is the way things are going, where you're going to be able to vote, and have discussions and do things like this and do another electronic things. So pretty soon I'm gonna have like a hologram of Lee sitting at the table next to me.
Oh boy.
A little bit weird. But anyway, thank you all. And thanks for the participants. And Tony, I'm gonna kick it back to you for the close. Thank you.
Thanks, Travis. And I echo Travis's comments. Thanks to our panelists. Thanks to everybody who attended today. We have more resources available on our website, fsresidential.com. We do this program every year. Maybe there'll be a year where we don't have to do it because the legislature doesn't tinker and just leaves what's there alone and lets us, digest it. That used to happen years ago. It doesn't happen anymore. And we'll be doing it earlier next year because, Travis, the legislative session starts in January as opposed to March. So we'll be looking for you again next year. We again thank you for your time, and we encourage you, if you have questions that you didn't get a chance to submit, go ahead and submit them. We'll answer them for you. But again, thanks for your time and enjoy the rest of your day. Bye-bye now.